Number 7, U.S. Bank National Association versus DLJ Mortgage Capital. Okay. Jim. Thank you.
Thank you.
Good afternoon, Counsel.
Good afternoon. May it please the Court, Barry Levin, Counsel for Appellant DLJ Mortgage Capital. I'd like to reserve 1 minute for rebuttal.
Yes, sir.
On this appeal, as well as in the next, the statute of limitations ran without the trustee providing the
Counsel,
contractually...
let me ask you, with respect to your argument regarding ACE, I'm a little bit, I'm having difficulty really appreciating the persuasiveness or the attempt to persuade on that. Didn't we say in ACE specifically that we were leaving open the question that's presented here about this condition proceeding and what effect it might have as to whether or not a plaintiff could rely on CPLR 205A?
So if you, the decision says that at the end, you're not addressing standing and 205A. But if you look, there were two issues. Just like today, there's two appeals. There were two issues before the court there. One was the statute of limitations issue, and one was the wrong party issue, which you're going to hear from my colleague on. And if you look in the transcript at page 34 on to the end of the transcript, there was a discussion about 205A in the context of the standing issue. But the court never addressed the statute of limitations issue in the context of 205A. And if you read the decision, it plainly says that the court found that the trust simply failed to pursue its contractual remedy within 6 years of the alleged breach. It plainly affirmed the decision of the First Department, which in the first line held that the action is barred by the 6-year statute of limitations, right in the first line of the First Department's decision. There's no suggestion in the opinion that it was affirming on any ground other than the statute of limitations. We submit that ACE clearly did hold that, and that was the right decision, that what you have here is the same sole remedy provision this court has seen now on numerous occasions. It's the only remedy available to the trustee. It's a mandatory alternative protocol. It requires notice in a 90-day cure period. It wasn't provided. As a matter of policy, parties should be incentivized to make use of such mandatory remedies. It would deprive the parties of the benefit of that remedial provision to allow the trustee to file a lawsuit on the last day of the statute of limitations, essentially as a placeholder to try to toll the statute of limitations, and only then provide the required notice. It would read the notice provision out of the contract, and we submit that the court should not permit that. And we don't think 205A...
What are the elements of the cause of action?
The elements of the cause of action are, in this case, notice to AmeriQuest, which was the originator, allow that 90-day cure and repurchase period to run, and then it must demonstrate that, in fact, there was a breach of a representation
I
of
thought
warranty.
the cause of action was that last one, that you breached the representations that accrue at the time that the agreement becomes effective, that
Exactly.
contains those representations. There's nothing to do with the notice and the cure/repurchase provisions.
So if you go back to ACE, that plainly was the first holding in ACE, that the claim accrues at the closing of the transaction, because if there's a breach, it occurred at that moment when the transaction closed. That's the same here. The provision here, the 2.03 section
Well,
of...
that's the alleged breach, right? That's the
Yes.
6 years. It's nothing
Well,
to do with
it's-
the other provisions.
It's all in the same provision, Your Honor. There's only one provision at issue here. It's 2.03, and that provision, number 1, says it's the sole remedy for a breach. Number 2 makes clear the breach is the breach of the representation on warranty. Number 3 says that notice must be provided. There must be a 90-day cure period. That's designed as an alternative remedy to avoid litigation. They simply didn't do it here. It's all part of the same provision. And what this court held in ACE...
So you moved to dismiss on the basis that there's a fatal defect in the complaint. They have an alleged notice, right? That's what happened. And the court says, yes, you're right, they haven't. So we're going to dismiss without prejudice for them to make that allegation.
So this court has only addressed this type of issue in Yonkers versus Port Authority, which we submit as a case just like this one. In Yonkers, there was an alternative remedy. The plaintiff did not pursue it. And in that case, the first suit, which was actually filed timely, was dismissed on the merits. And when the plaintiff then attempted to comply with the remedial protocol and then rely on 205A, this court prohibited them from doing that. And the only cases where this court has...
In Yonkers, the court held that it was a substantive condition precedent, not a procedural condition.
But not in the sense that it delayed the accrual of the statute of limitations. To that extent, it's just like this case. There was no dispute that the statute accrued on day one, and you had 1 year from that point to file a lawsuit. That's exactly what's going on here. They had 6 years to file a lawsuit, but they had to give the timely notice within that 6-year period.
Yeah, but the whole claim turns on whether or not you complied. They claim that there's not compliance with those original promises, the warranties and the representations. And they would have had to present evidence on that.
Well, they also have to
If
demonstrate
they
that
gave notice or not wouldn't matter with respect to whether or not there was compliance with that promise.
Well, then...
That's why I'm having difficulty with the argument, because I
with-
do see this condition proceeding as
With respect, if they haven't complied with the condition precedent, then they've simply not met the contract requirement that they agreed to, that the trustee agreed to as the sole remedy for breach. If
Can
come
I
back
ask
for
this?
one-
For us, is the question for us, if we get to the procedural condition precedent, is whether or not it's a final judgment on the merits, or are you saying that all condition precedents, whether substantive or procedural, a decision on them constitutes a final judgment on the merits?
We're not saying the latter, Your Honor. All conditions precedent are not created equal. If you look at the cases that have been decided by this court and are cited in their
Well, I'm
papers,
thinking,
Morris
the language I
Investments-
drew from was Carrick, but...
Carrick. So
Fine.
Carrick, there was no dispute that the suit was timely filed. They had the wrong party. They didn't have the administrator appointed, and the court carved out a narrow exception for that one thing. In
So
Morris...
I don't mean to interrupt you, but you only got 5 minutes. Do you think that the test for us to apply is whether or not a final judgment on the merits has been made?
I would say it slightly differently. I would say the test to be applied is whether the plaintiff filed this lawsuit timely, and to file the lawsuit timely under the sole remedy provision that the trustee agreed to, they had to first provide notice in a 90-day cure period, because that was designed to be an alternative remedy to avoid litigation. And of course, in ACE, notice was provided before the statute ran, but the full 90-day cure period was not allowed to run.
We'd still be in the same position on the question of finality of the judgment.
Yes, because if it's untimely, then it's on the merits. And the other cases where this court has ruled on conditions precedent, like the Morris case, the Alouette case, the Fleming case, those are cases where the condition precedent was imposed by statute, not by contract.
What's the basis for, why should we distinguish between those?
Because where you've got a condition precedent imposed by statute, you're balancing one statutory provision imposing some requirement, for example, to deposit taxes, against another statutory provision, which is 205A. But here the parties made a decision by contract to say that if you want a remedy under this contract, under all of these contracts, you first must provide the notice and allow the 90-day cure period to run. If you allow them to avoid that provision, you've essentially read that provision out of the contract.
Thank you, counsel. Counsel?
May it please the Court, Philippe Salendi for U.S. Bank. This case presents a classic application for a Rule 205A refiling. The ABSHE trustee did in fact timely file the action under Rule 213.2, and it properly served a summons with notice under Rule 304, which, as this Court held in Fleming, governs when the timing occurs upon commencement. The case was dismissed without prejudice.
Why
for
isn't the
a
notice and
technical
cure,
defect.
respond to his argument that the notice and cure/repurchase provision is part and parcel of this cause of action?
It cannot be. This Court held already that the repurchase protocol is a procedural issue. It doesn't And not only is it not a substantive condition precedent, but it cannot therefore be a substantive condition precedent that sets a time limit as an ingredient of the cause of action, which is what this court held is required in the Yonkers case in order to make 205A inapplicable.
Where did we say it's not a substantive?
In saying that the cause of action, the repurchase protocol is solely procedural, you exclude the possibility of it being an element of a cause of action.
Saying, but where did we say that? You said we've already said that.
In the ACE case itself, and you reaffirmed that in the Deutsche case by indicating that the cause will not accrue depending upon whether the repurchase protocol has been satisfied or not. It's irrelevant to accrual. That's because it's procedural. What that means, and I think this is conceded by DLJ, is that the only relevant time period here is the statute of limitations in 213 itself. That is on the opposite side of the fault line, the chasm that this court created in Yonkers, saying if it's a statute of limitations, then 205A can apply. By contrast, if it's something more than that, a requirement, as in Yonkers, where the waiver of sovereign immunity was conditioned upon satisfaction of a time element, if it's something more or in addition to the statute of limitations, then 205A doesn't apply.
If we agree with you, do we have to reach the question whether or not that notice and cure/repurchase provision requirement has to be satisfied within the 6-month savings clause period? Do we need to get to that question?
I would say, Your Honor, that in this case, it was in fact satisfied within the 6-month savings clause, so the court need not reach that. But I will point out that the core argument made by the appellants here is that because this is a condition precedent, it must be satisfied before the expiry of the statute of limitations. This court has repeatedly rejected that exact argument in Fleming, in Carrick, in Morris Investors. Again and again, the court said that the condition precedent could be satisfied after the expiration of the statute of limitations, and the procedural defect could then be cured under the 205A refiling. There's just no precedent for the suggestion that instead the condition has to be satisfied before, and indeed that would make a mockery not only of those prior Court of Appeals decisions, but a long line of cases from the First Department and the other departments, which we've cited in our response to the SIFMA amicus brief, which I commend you to. And indeed, this rule, the whole purpose of this rule, it's a broad and remedial rule, as Judge Cardozo said in the Gaines case. It has antecedents for hundreds of years. It was first adopted in 1788 in New York. It's been repeatedly reaffirmed. The only significant change is that in 1962, the one-year grace period was narrowed to 6 months. But time and again, the legislature has said that if the action is timely commenced in accordance with 304 and within the statute of limitations period, then the plaintiff has the ability to refile for a procedural defect, i.e. a defect that does not go to the merits, provided there has not been any failure to prosecute, and no such failure has been alleged here.
I'm sorry. Counsel, are you circumscribing your presentation and your argument only to the procedural posture of this appeal, or are you also implying, if you succeed, that in going back to Nisi Prius, you are going to prevail on the merits? Are you weaving that in and out of the argument?
No, Your Honor. The issue of the merits are really not even addressed. It was not hit. That turns on the extent of the rampant breaches, the alleged rampant breaches by DLJ of the reps and warranties concerning the loans. That question never arose. That's why, under this court's ruling in Carrick, the dismissal for failure to satisfy the repurchase protocol cannot be a judgment on the merits. There's been no adjudication of any kind relating to the merits of the case.
Is it then safe to say that both ACE and Deutsche Bank Flagstar are solidly in the corner supporting your argument?
ACE and Deutsche Bank are solidly supporting us, as does Yonkers itself, because all of these cases are drawing the distinction between, on the one hand, a procedural condition precedent, and on the other, a substantive one that incorporates a time limit as an ingredient of the cause of action, which obviously we do not have here. And I'll point out, DLJ, had they wanted that, could have written it into the contract, Rule 205A is just as much a part of the CPLR as is Rule 213. Every contract for literally hundreds of years in New York has been written against the backdrop of those two rules working together.
So what are you saying that could have been negotiated? What could have been this language?
DLJ could have said, look, if you wish to exercise this sole remedy, you have to exercise it within a certain number of years. And they could have tried to define a time limit rather than defaulting to CPLR itself, which under Rule 213 gives 6 years, as modified where applicable by Rule 205A. Having failed to do that, they should live by the benefit of the bargain, and that means that in this case, as is true in 205A cases generally, and indeed not just in this state, but across the country, where 42 other states have similar rules, 29 of which followed
And just to be
Judge
clear,
Cardozo.
your position is not that at some point, the trustee has got to satisfy the notice requirement and give that opportunity.
Absolutely, and
Your
the
point is
trustee
it just
did in
doesn't have to
fact.
be in the 6 years, the
Correct.
original 6 years.
Correct. That's exactly the purpose of the savings provision, to try and correct that technical defect. The trustee did in fact completely abide by the repurchase protocol. I'll note that in this case, they did give notice to DLJ 5 years and 4 months from the closing of the trust. The only reason why a second repurchase demand was required is that it's a guarantee obligation. And so they were held to be responsible for the formal notice to the defunct originator in order to then pursue the guarantee
And if they at
against
that
DLJ.
point complied, then perhaps that takes care of the litigation, and if not, you move forward on the merits about the breach of the warranties.
Correct, and I'll just flag for the court, we do have an independent basis to go forward on the guarantee claim alone, but we submit that the 205A application is about as simple and clear as it could be. The rule is straightforward. This court declined in George to adopt any of the new exceptions that plaintiff and, that DLJ and SIFMA has proposed, and the rule should be applied here, and the First Department affirmed.
Thank you, counsel.
Thank you.
Mr. Levin?
We do not concede that the case was timely filed. Counsel stated that if we had just negotiated the right contract, but what the court told us, what the Supreme Court decision told us, which is not challenged on appeal here, is that in order to affect the sole remedy provision here, the trustee must first give notice to AmeriQuest, which is the originator of the loans, and allow AmeriQuest a 90-day period to cure and repurchase. That didn't happen within the statute of limitations. They simply didn't do anything at all. He's right, they gave notice to DLJ, but we negotiated a contract that required notice to this other party, and that notice wasn't provided. We think this is directly like the decision in Yonkers.
Can you address his point about the remedial nature of the statute, and that it's supposed to be given a liberal interpretation and not to be treated frivolously, if you remember some of that language from the cases?
So the cases talk about protecting the diligent suitor, and this was not a diligent suitor. The contract is clear. The requirement is clear. They knew how to give notice. U.S. Bank is before this court and other courts in the state on many of these. They simply didn't comply with the provision here. There's no reason, if we're seeking certainty and finality, which is what you seek from the statute of limitations, there's no reason here to provide any relief under 205A, because the parties did exactly what counsel suggested we should do. We negotiated a specific provision requiring notice as an alternative to litigation. They didn't honor that provision. It's not that they could do it, well, Your Honor asked, could they do it after the 6-year period? The problem with that is that what the Deutsche Bank tells us is that even if the parties tried to negotiate for something that extended the statute of limitations beyond 6 years, you can't do that, because at the time of contracting, you can't have a contract that extends the statute of limitations beyond 6 years.
You wouldn't be doing that, would you? Because they filed
So
an action.
they did file the action, but we submit the action is not timely filed, because if you allow them to proceed without having allowed the cure period to run, then they've effectively taken away the very thing they said we were supposed to do, negotiate that protection. We negotiated that
Yeah, but I think
protection.
the point is the second argument you're making rises and falls with the first. So if we disagree with you on the first, this one also fails.
Yes.
Speaking for Judge Stein, but I think that's where
I
she was going with
understand
the
that,
question.
but we submit, there's no question here that the statute accrued on the date of the breach, which is the date of the contract, and as a small aside, We submit that, in fact, they're suing on two contracts. The other one is the mortgage loan purchase agreement dated October 23, 2006, which is more than 6 years before. That's addressed in our briefs, but even if you assume it's November 30, when that statute of limitations ran, they had not provided the notice that we bargained for or allowed the cure period that we bargained for. And this makes this case like Yonkers and unlike Carrick or Fleming or the other cases this court has decided, and where the parties have specifically negotiated for that relief. There's nothing in 205A that should let them get around it.
When you negotiated this term, there wasn't clear law saying that the notice and cure/repurchase obligations had to be met within the 6-year statute of limitations, right? I mean, there wasn't clarity at that point in your position.
I would concede that there was not clarity, but the contract is clear that they have to provide that notice. There's no appeal here that the contract doesn't say what it says, which is you must provide notice in a cure period.
Yes, well, the question is whether or not they had to do that within the 6 years. So, of course, there's clarity that is what they negotiated.
So we would say the relevant law was Yonkers, which was 1999, which was actually the most recent time that this court has addressed 205A, and in Yonkers addressing a similar remedial provision. They're requiring that a matter be submitted for resolution before the chief engineer of the city. The court said, you fail to honor that, you can't rely on 205A, and we submit that's exactly the issue before the court here.
Thank you, counsel.
Thank you.
The next appeal on the calendar is Appeal Number 6, U.S. Bank National Association versus DLJ Mortgage Capital. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, Hector Torres for the appellants, and I'd like to reserve 1 minute for rebuttal, please.
You may.
The order dismissing the trustee's complaint should be reversed based on well-settled, clear-cut standards with respect to the savings statute and relation back that have been applied by this court and other courts in multiple cases for decades. For the savings statutes, the courts have focused on whether the same interests and rights are being vindicated in both the original and the revival actions. Here, there can be no dispute or no genuine dispute that the same rights and interests were being vindicated in both the original actions that were filed by FHFA and in the revival actions.
But you know, the trustee had the opportunity. The trustee is informed by this federal certificate holder. The trustee apparently made a decision not to move forward.
Your Honor,
Why should they now get the benefit of the 205A savings provision? Really, where's the due diligence? But here, it's even different to me from the prior case, not lack of due diligence. It's specifically, you put on notice, and it sounds like the trustee made a decision, which the trustee is allowed to do under the provisions, of course, of these agreements, not to proceed.
Except, Your Honor, that here, what is in the record is that notice was provided to the trustee and the actions weren't commenced within the period. However, if you look at the rule, it really does not contain a requirement that the notice be provided in a way that is consistent with that standard. In other words, the rule essentially has 3 elements. One, that you provide, that you indicate that you've provided the action timely, that it was timely commenced. The second is that there hasn't been a dismissal based on the merits. And the third is that you give notice to the defendant. Here, all of those requirements have been complied with. With respect to, there's no additional requirement because for purposes of determining... Yes, but in terms
of the remedial nature of 205A, and given the role that the trustee plays in this RMBS securitization, it does seem a little bit strange, let me just say that, to allow a trustee to be put on notice within the statute of limitations period, to appear to affirmatively make the decision not to move forward within that time period. Therefore, the certificate holder acts, and now the trustee wants to say, you know, I want to get the benefit of that. I guess it might be a good action after all.
I guess the only thing I would disagree with it there is where it appears that they intentionally made the decision not to proceed with the action. I mean, here what actually happened was that notice was provided, and shortly after the actions were filed, the trustee substituted as the plaintiffs for all three actions.
Yes, so I
So
saw
you can
that.
draw whatever inference you can, but in other words, there's no state of mind requirement under the statute.
No, but there is a remarkable lack of urgency. That's what strikes me across the board in many of these cases. Now, here, there was a forensic evaluation done here, wasn't there? And they found that 90% of the loans failed to comply with the forensic evaluation said that 90% of the underlying loans were bad. Is that correct?
That is correct.
And that took 4 to 5 years to complete, which is mind-boggling to me when there's billions of dollars at stake, but apparently that's what happened. And then still, there's no action that's taken place after that. And as I understood the factual scenario, that AmeriQuest shut down in 2007, so everybody knew there was a problem then. So how are we to view this lack of urgency? Is there a legal basis upon which we should view it?
Well, Your Honor, first it's important to understand the factual context with respect to these deals. There was no independent obligation on behalf of the certificate holders or the trustee to go out and examine thousands and thousands of loans.
All you'd have to do is just be alive in 2008 to know that there was something wrong, and to say to yourself, maybe I should check on these particular problems in these investments.
But the issue, that's in retrospect when we see what has happened in the market.
I remember 2008. It wasn't retrospect for me. It was common knowledge. It was in all the media. There was threats that the economy was going to collapse, and these were part and parcel of that economic problem. So that shouldn't be laid on you. I don't attempt to do that. I'm not doing that. What I'm saying to you is, how should we view this in a legal context in terms of the awareness and the application of any special benefit?
Well, Your Honor, in a legal context, it's a question of a straight application of a clear-cut standard that's set forth in 205A and the way it's been applied by the courts. Mm-hmm. And essentially, you have the requirements, and if you have the same party and interest that that was provided.
But haven't we really, I thought, made kind of clear that that we were reading the statute as it was written, and that we were really talking about the substitution of a representative for someone who's deceased, not just people that had similar interests.
Right, well,
Even assuming that these two parties do have similar interests, and that obviously is a question in and of itself.
The parties obviously have, the trustee has its interest in terms of administrating the claims, but clearly here, the certificate holders had substantial economic interest in the cases. And what the rule provides and what the courts have provided in reliance is that if it's the same interest and rights that are being vindicated by both the original action and in the revival
I realize there was
action.
some language to that effect in some cases, but I think that's sort of taken out of context. I think that we've consistently not applied 205A in circumstances other than where it's a clear representative of a party who cannot appear. And that, I mean, here you have a contract with very distinct rights between the certificate holders and the trustee, and a whole, right of action provision and all of that. And so doesn't applying the rule that you're suggesting really undermine that whole thing?
Not at all, Your Honor, because of the fact that they are the same interest and rights that are being adjudicated. And this court has never clearly held that it would not apply this statute. It only requires that an administrator or an executor, but more importantly, in the George decision, where the court did make the statement that it should be applied if the subsequent claimant is acting in a representative capacity relative vis-a-vis the original action, or the plaintiff in the original action, then it should be applied. And here, that is precisely what occurred.
Judge, could
Yes.
I ask, I know this red light's on, but
Yes,
there's a
please.
question I didn't want counsel to not be aware of that I had in my mind. there's a difference between arguing that 205A would be improper because of the identity of the plaintiff versus 205A would be improper because the original action was untimely. Follow me?
Yes.
Okay. Are you arguing identity or untimeliness? You're arguing
Well, we're arguing that both with
one or the other.
with
No,
respect-
no. My question is, you're arguing one or the other, identity or untimeliness. You didn't argue both below.
Well, we're not addressing the timeliness issue
All
because
right, so-
we're
so-
basically
So let me
taking the
just ask
position
this
that-
question. If you didn't argue the untimeliness issue below, but you argued the identity issue below, is the untimeliness issue preserved for this court?
Yes, Your Honor. It was argued at the Supreme Court level, so that issue has been preserved. And
I didn't
with
see it there,
respect-
and the appellate division didn't address the timeliness issue. I don't believe they addressed the timeliness issue
Well,
at all.
they just addressed the relation back and the condition preceding issues,
Right.
but they're related, and one of the premises of both relation back and the savings statute is that there be a timely action, and for purposes of a timely action, here clearly that was complied with because the three actions, when they were filed by FHFA, were filed within the statute of limitations period.
I see. Okay, thank you.
Judge Rivera, one more question, sir, before you leave.
Chief, thank you very much.
Sorry,
Counsel, I'm sorry, if you don't mind. The action has to be commenced, but the initial plaintiff has to be the right plaintiff.
Yes.
That being the case, how do you survive the precedent of the court and reliance on these facts, given the identity of the initial plaintiff versus the subsequent plaintiff?
Well,
In the context of 205A, assuming you don't have a preservation issue.
Well, the question is...
Check that preservation problem.
Correct. The question is how you define the plaintiff for purposes of 205A, and what we're submitting is that under reliance and other cases that have been decided in the New York courts, the courts have made clear that you look at whether the same interests and rights are being vindicated by the original plaintiff and by the revival plaintiff. And here, that clearly is the case. So the court has never really applied a strict rule that relies solely on the identity of the plaintiff. If that were the case, then reliance would not provide the analysis concerning the same rights and standards, and you wouldn't have decisions like Pinto and Genova and Green, where you had a situation where you had a debtor versus a bankruptcy trustee, and in those cases, even though nominally they were distinct plaintiffs, the courts permitted the revival action because it was clear that the bankruptcy trustee was representing and seeking to defend the interest and the rights of the debtor on behalf of the estate.
But are you, excuse me, but are those conclusory statements that you have just made, are they in the ambit of what an advocate must state in order to advance the client's position, or is it a reasonable, rational, and balanced reading of what the court says? In reliance.
It's a reasonable and balanced
It's not as
reading.
if we have a third party whose rights are being aggrieved and sought to be vindicated by two different entities.
No,
In
no.
the context of 205A, you need to have the proper plaintiff.
Exactly, and you have the proper plaintiff here for the reasons I stated before, and because here, the certificate holders, and this was initially filed as a derivative action by FHFA on behalf of all the certificate holders, the certificate holders have always held and retained economic and equitable rights to the claim. The certificate holders are the key, the real parties in interest.
Yeah, but the problem really with that argument is, and the court has said this before, that there are different certificate holders. They take different priorities. And so the trustee's interest, even under your analysis, might very well vary across these various certificate holders. The case is not going to boil down to Freddie Mac's particular certificates and its status, right? It's about the breach of the warranties and guarantees and the impact and what might be the recovery for all certificate holders.
I agree with that, Your Honor, with the exception that in this case, FHFA, when it filed the action, was not filing it on behalf of FHFA only, and was not only seeking recovery on behalf of that entity. When it filed the action in a derivative capacity on behalf of all the certificate holders.
But it could not do that. Could not do that.
In a derivative capacity, that's the way the action was filed. And what's critical is for purposes of notice, once they provided notice that it was on behalf of all certificate holders, you basically complied with one of the cardinal principles and purposes served by the savings statute, which is to ensure that timely notice is provided to the defendant.
Thank you, counsel. Counsel?
Mr. Salendi referenced then Judge Cardozo's, talking about this being a liberal statute, but the Judge Cardozo also spoke to that it's to protect the diligent suitor. And this court in Norex echoed that and said that 205A relief was not intended where the proper party was unwilling to prosecute its claim in a timely manner.
Okay, well, why isn't the trustee in an RMBS securitization like a bankruptcy trustee?
Oh, it's very different. So in the bankruptcy, you have a legal transition from one entity to the other. Here the trustee was always, so in a bankruptcy trustee situation, it was not able to sue before. Now it's a state's a new entity. Now the first time the bankruptcy trustee is the proper party representing the same entity. This court in Reliance said where there's a commonality of the identity of the party from A to B, that the rule can still apply, but it doesn't apply in a situation where it's different parties. Here, the trustee always could have sued, and as you recognized, the certificate holder recognized it itself. They knew that they were barred by the no action clause from suing. They were barred from the no action clause from giving the notice and cure notice. And they sent a demand letter. That's in page 1549 of the record.
And could they have sued derivatively? What about his argument at the very end, before he sat down?
No, they have no authority to bring an action on behalf of themselves or other certificate holders. That's what the no action clause is allowed. They want to incentivize and reward the certificate holder for breaching this key term, the no action clause. And if you reward it here, you're going to incentivize other minority holders of bonds and certificates to do likewise, to extend both the limitations period and to put pressure on the trustee to bring in action. So the trustee here was given a demand letter. It has the fiduciary responsibility to the junior holders, the senior holders, to the trust itself, and to future holders. And it knew how to give notice and seek notice and cure. It knew how to sue within the 6 years. It knew the 6 years was expiring because the demand letter said, you better sue within 8 days or our rights are going to be compromised.
So is the 205A argument even preserved? Could you address the preservation issue?
The preservation argument?
Preservation issue.
Their argument's preserved?
No, whether it's preserved or not.
In other words, did they?
Can we even consider this argument in this appeal?
Well, it was dismissed by the trial court as time barred.
So that's timeliness, that's not identity.
And they then appealed that. They did not seek to reverse that holding. They said instead of being a dismissal with prejudice, we'd like it to be a dismissal without prejudice.
Yeah, but did they make that argument in the Supreme Court? In other words, when you moved to dismiss and they opposed that motion, did they say if it has to be dismissed, it should be dismissed without prejudice?
Not to my knowledge, Your Honor.
Because of 205A, was Reliance cited by anybody?
They never sought 205A relief in the trial court. And on the appeal, they said, change it to a dismissal without prejudice so we can, at a later time, seek relief under 205A.
So just to clarify, for me, the record, as I understood it on your motion to dismiss, you did, albeit in a footnote, raise the 205A and said they can't rely on that. Did you not?
That's correct, Your Honor.
And they never responded to that argument.
Respond to that. It was
They
a
never
dismissal.
mentioned 205A. It's not anywhere found in their brief in response.
And never
Correct?
filed a 205A, complaint. They filed a consolidated complaint after, the only time the trustee filed was after the limitations period had already run, and the trial court correctly dismissed that as.
As I understood, they were arguing that they should have been allowed to file an amended complaint, but they didn't make this argument over 205A
No, they
in
did not.
response to your
They
motion.
did not, Your Honor.
Okay, thank you.
Now, as you noted, that the parties here are very distinctly different. There's a fiduciary responsibility of the trustee to all the certificate holders and to the trust. The certificate holder has only a fiduciary responsibility to itself and to its own economic interests. They have different rights and they have different interests, and the reason they have different rights is because they have different interests. And finally, he's, in essence, is trying to have this court overrule the Reliance decision. So in Reliance, this court said that it explicitly and exclusively applies to where it's the same party that initiated the action. It is the only party who can then invoke
The
205A.
same rights language, the same rights test. What's your response to that?
It was simply referencing and quoting from another opinion, but then went on to clarify that even where, in that case, there was 100% the same interest. It was a wholly owned, so it's a parent owning 100% of the subsidiary. So the economic interests were completely aligned. And this court in Reliance said that's not enough because the subsidiary is not the parent. They are different parties.
What's the problem with that test?
Different as my colleague here said, you need to have clarity under the rules. He's asking this court to adopt a very fuzzy test about an alliance of interest. And here, the alliance of interest between the certificate holder, a minority who's just looking after its own economic interest, and the trustee, who is the only party, the sole party who can look after the interests of all the certificate holders, is quite different. So this court should stick to Reliance and say you need to have a commonality of identity between who brought the initial action and who's filing under 205A, with the only exception being the representative in the state, or, as Reliance recognized, where as a matter of law, it now has a new label, but it's still really the same identity, the same party. Here, it wasn't the same party. The party who initiated it was a party who had no authority to. As a certificate holder, who's not the same party as the trustee, did he say, yes, we are the certificate holder bringing it, trying to bring it on behalf of the trustee? Sure, they said that, but they had no authority to do that. The party who is initiating it under Reliance is, in fact, is the certificate holder and a different party, and the First Department correctly, therefore, said it was dismissed and properly dismissed with as time barred, and that no 205 relief can be sought.
Thank you, counsel.
Thank you.
Mr. Torres?
Mr. Torres, can I ask you a question? Your adversary brought up the point about the no action clause. If we accept your argument that, in fact, that there's the relation between the certificate holder and the trustee, are we, in essence, abrogating the obligation under the PSA that has the no action clause?
Well, not at all, Your Honor, and the reason for that is that in this case, the trustee actually has filed in the amended complaint. They actually submitted an amended complaint in paragraph 7 that includes a reference to compliance with the no action clause.
But of course, all that's after the fact. The certificate holder is the one who commenced this.
Right, it is after the fact, but the fact is that to the extent that they're relying on the no action clause, A, that's been complied with, and notice was provided more than 5 years ago, and they have not purchased the overwhelming number of these loans. But secondly, to the extent, the no action clause really boils down to this. There was a defect in the original action because you didn't comply with this requirement. It was a condition precedent requirement. We admit that. We didn't comply with it. And for purposes of 205A, however, the fact that it's a defect, even if classified as a fatal defect, is not dispositive. In fact, as George stated, that's the precise reason why you have 205A, to deal with situations like this where you have a fatal defect in a claim, whether for a condition precedent or for some other reason, as long as it doesn't go...
Why didn't you argue that in response to the motion to dismiss? I'm having a problem with the preservation issue here.
Well, Your Honor, it was argued in connection with, when the case came up, there were two arguments that essentially were made. One was the relation-backed document under 203F, and under the relation-backed doctrine, by virtue of the close relationship between the FHFA as the derivative plaintiff for the certificate holders and the trustee were closely related, so they clearly meet the requirements. With respect to 205A, an alternative argument was presented that that you wouldn't even have to get to relation back. In other words, you had two options for purposes of getting to the same resolution, which is sustaining the lawsuit.
This was presented on the motion to dismiss?
Yes, that was the argument that was presented.
You argued on the motion to dismiss?
Yes.
That you had the opportunity to invoke 205A?
Well, where
would I find that in the record?
No, we made the argument in the papers. There were basically two grounds for...
I'm sorry, where would I find that in the record?
That's in the briefs.
In opposition to his motion to dismiss?
Yes.
All I saw was your argument that it was timely filed, the original action was timely filed, and in the alternative, you wanted the opportunity to amend the complaint.
No, Your Honor,
pursuant to a different section of the CPLR.
Right. No, it's clearly, if you look at the briefs, it's clearly that there were two grounds essentially were argued for purposes of reversing the order below. One was that 203...
Oh, you're saying you argued to the appellate division?
Correct.
No, I'm asking you about the Supreme Court. Did you put this in your briefs to the Supreme Court?
Well,
You have to preserve it at the trial level before this court can review the argument.
In the Supreme Court, it was the 203F argument was made. It was not made in the appellate division because the ACE decision had come down, which essentially decided exactly the same issue, but because the argument was made at the trial court level, it was preserved, plus the appellate division did consider the argument based on the record in this case, and they did make the determination with respect to 205A, and that was one of the alternative grounds where it was dismissed. So the combination of having raised the argument at the trial court level and the fact that the appellate division...
I'm sorry, the Supreme Court issued a ruling on 205A?
No, the Supreme Court issued a ruling dismissing the action with prejudice with respect to 203F. When it went on appeal, the arguments were made that with respect to 203F, the action should be sustained, or with respect to 205A, the action should be sustained, and there were alternative options to get to the same end result.
So when they raised this in their motion to dismiss, in their brief, in the footnote about 205A, your brief did not respond to that?
Well, we did respond.
At Supreme Court?
Oh, at Supreme Court, it wasn't an issue at Supreme Court. So the point is that it was an issue that was decided by the appellate division, and it was connected to the findings that were in the record with respect to the structure of the transactions and the actions of FHFA as a derivative plaintiff.
Thank you, counsel.